table is a privately retained interpreter to be used for conversations between the defense attorney and his client. Mr. Rivera, are you able to understand today's proceedings through the interpreter?
Yes.
The defense has filed a motion for a private hearing. The defense has also filed a resistance to the use of the expanded media. We'll hear arguments on that motion first. Mr. Richards?
May it please the court, Mr. Prosecutor. I pulled a case law this morning from the Iowa Court of Appeals. And it's State versus Jack Hayes, filed October 3rd, 2012. It's number 2-701/11-0669. There's a little piece in that case that talks about expanded media coverage. This particular court, the court there granted the expanded coverage. But the Supreme Court concluded that it's within the discretion of the judge to exclude the expanded media coverage based on circumstances of the particular proceeding. Such coverage would materially interfere with the rights of the parties for a fair trial. And it's based on constitutional rights. And essentially, the prejudice here is the decision beforehand to lean in favor of one side or the other, which prevents justice. In this particular case, the coverage that's out there is leaning all one way. And in fact, the government has weighed in at the highest levels of a predisposition that this young man, Cristhian, is guilty. But in our system of justice, he's entitled to that presumption of innocence until some evidence is presented. At this time, there's been no evidence presented, Your Honor. And so we're urging the court to prevent the cameras from coming in here, which possibly could show some sort of bias or prejudice, and get it into this political controversy of portraying Cristhian as something that he isn't. In some ways, I view this as a political payback for what's swirling around in terms of the media. And the media is feeding into it. They have not made efforts, as far as I can see, to give justice or any type of leaning towards this presumption of innocence. And therefore, we're asking this court to exclude the media from these proceedings, because it could be just one nod of the head, one glance, one sleight of hand that will be partially taken out of context and presented over and over, which would be highly prejudicial to the defendant. So I urge the court to exclude the media from these proceedings.
Thank you. Mr. Brown, would you like to make an argument?
Yes, Judge. We have, first of all, the state has no objection to the expanded media request that's been filed. I think they followed proper procedure here. Mr. Grove, I think, is the regional media coordinator. It's very routine in cases that garner some sort of high profile that the media has interest. The Supreme Court has provided rules for the court to follow in allowing media coverage of cases and court proceedings. So we would have no objection to the expanded media request. There's been one request for a video camera, one request for a still camera, again, which is very usual under the circumstances of cases like this. This is certainly not the only high-profile case or case that has garnered media attention in the state of Iowa. So we have no objection to the media, expanded media request. In this case, I would assume that once this case proceeds beyond initial appearance, whoever the district court judge that is assigned to this case will probably readdress that issue. Secondly, there's been a motion filed, I just got this whenever I walked in this afternoon, but a motion for private hearing pursuant to Iowa Rule of Criminal Procedure 2.24. I think that's what Mr. Richards here was referencing whenever he was arguing that there's a substantial probability that the defendant's right to a fair trial will be prejudiced by the publicity that closure of this particular proceeding would prevent. He has not identified anything that would happen today in this particular hearing that would create any type of substantial probability that his fair trial would be impacted. He wants to talk about whatever the political discourse is that's been surrounding this charge or this case. Certainly we have no control over that. But it is what it is at this point. I mean, there's a lot of information that's out there about this case, about this particular charge. I think all the court is going to do is follow Rule 2.2 in the initial appearance, advising him of his rights, making sure he's got counsel, that he's either retained or appointed, and addressing the issue of a preliminary hearing and whether or not he demands that. I fail to see how any substantial probability of any impact on the defendant's fair trial would be raised in this particular proceeding. So we would ask that the motion for private hearing be denied and that the expanded media request be granted. Thank you.
If I may respond, Your Honor,
Briefly,
procedures weren't followed. I entered my appearance this morning, attempted to shortly after 8 a.m. The e-file system was down or crashed. I did not see the motion for expanded media coverage until 12 o'clock today. And if that motion was filed yesterday, Cristhian was still self-represented. He was never served a copy of that notice, and I was never received a physical copy, although I do acknowledge I did see it at 12 o'clock today. It was my first opportunity, first knowledge that the e-file system was back up. So the rules haven't been complied with, and I would object on the rules, being the prosecutor says the rules were followed. They were not followed.
Mr. Richards, I'm aware of the fact that we had technical difficulties this morning with the e-filing system that the Iowa judicial system uses. Because I was aware of that, I made contact with both you and Mr. Brown, notified each of you of the expanded media coverage first thing this morning, explained the difficulties we were having in making the paper copies available to you, and said that as soon as you arrived at the courthouse, we would make everything available to you if EDMS was not available at that time. I believe we've followed the procedures that are available to us, and we have gone out of our way to make sure that while we were having technical difficulties throughout the state, that we were making you aware of things that were being filed. In fact, we allowed you to file an early appearance by fax, which would not be a normal procedure, because EDMS was down also. So you did take advantage of the fact that the court was working with you and trying to accommodate for the technical difficulties we're having. At this time, I'm going to rule on the motion for a private hearing and also the request for expanded media coverage. With a reminder to everyone that the defendant will not be asked to make any statements related to facts in this case today, I make the following finding. The defendant's right to a fair trial is not prejudiced by the publicity as related to the initial appearance. Reasonable alternatives have been established, including limiting media coverage to one video camera and one still camera. Today's initial appearance will be held in open court, and the media will be allowed to stay in the courtroom. Mr. Richards, you also filed a motion for a gag order, and in discussions that were held off the record prior to today's hearing, you indicated that you intended for that gag order to be heard by a district court judge. Is that still your intent?
I believe that's the proper procedure, Your Honor.
Okay. I will file a calendar entry asking the district court to set that for hearing. We are now going to move on to the initial appearance. Mr. Rivera, this is your initial appearance on the charge of murder in the first degree and on an immigration detainer notice of action filed by the Department of Homeland Security. The purpose of an initial appearance is to make sure you understand the charges against you, to review any request for an appointment of an attorney, to set further proceedings or court dates in this matter, and to discuss your terms of release from jail. Mr. Rivera, do you have any questions about the things we'll be covering today?
No.
Mr. Rivera, you have been charged with murder in the first degree in violation of Iowa Code Section 707.2 sub 1 sub A, a Class A felony. Mr. Rivera, have you been given copy of this paperwork?
Yes.
The Department of Homeland Security has filed an immigration detainer notice of action for you. Mr. Rivera, have you received a copy of this paperwork?
I believe so.
Mr. Rivera, I'm now going to review rights that every defendant has in a criminal action. These include the following. You have the right to an attorney. Every defendant has the right to retain legal counsel and shall be allowed reasonable time and opportunity to consult an attorney. In the event you are indigent and desire counsel, and if the offense is a serious misdemeanor or greater, an attorney can be appointed to represent you. Mr. Rivera, at this time you are represented by a privately retained attorney, Alan Richards. Do you wish to continue with this private representation, or do you wish to file an application for a court-appointed attorney?
No, with Richard.
Mr. Rivera, if at any time today, during today's proceedings, you wish to talk to your attorney, please let me know, and I'll stop today's hearing.
Okay.
Next, you have the right to be released from custody. Every defendant in custody has the right, subject to conditions, to be released from custody pending judgment. A defendant may be released from custody on his or her own personal recognizance or on conditions as the court determines, as will reasonably assure the defendant's appearance as required and will reasonably assure the public's safety. If the court imposes conditions for defendant's release and defendant is unable to meet these conditions, the defendant has the right to request a bond review hearing. If the defendant is indigent and unable to retain legal counsel, the court will appoint an attorney to represent you for the purposes of this bond review hearing. Next, you have the right against self-incrimination. A defendant is not required to make any statement concerning the offense charged to the court, to any law enforcement officer, or to any other person. But if the defendant makes any such statements, those statements can be used against the defendant. And finally, defendants have a right to trial. Every defendant has the right to a trial and to be tried by a jury.
The judge in the Mollie Tibbetts case reading the rights to the suspected gentleman you see right there involved potentially in her murder. We're going to continue to monitor that event, but we want to take you live to the White House press briefing room where we're hoping to get the first comments from Sarah Huckabee Sanders.
Close coordination with the state of Hawaii and stand ready to support them in whatever they need. Also,